Dear Chief Acosta, my husband was prosecuted for the crime of robbery. On the day of the promulgation of judgment, he failed to attend because he was afflicted with COVID-19. Will there be any legal implication when an accused failed to appear on the date of the promulgation of judgment? I hope that you can enlighten me regarding my husband's situation. Bebang.
Dear Bebang, yes, there are implications if an accused failed to appear on the date of the promulgation of his or her judgment. Under Section 6, Rule 120 of the Rules of Court, promulgation of judgment is done by reading it in the presence of the accused and any judge of the court in which it was rendered. However, there are instances where promulgation of judgment can be done in the absence of the accused. These are 1. For light offenses, the judgment of conviction may be pronounced in the presence of his counsel or representative. Second, for other offenses, in case the accused fails to appear at the scheduled date of promulgation of judgment despite notice, the promulgation shall be made by recording the judgment in the criminal docket and serving him a copy thereof at his last known address or through his counsel. In the latter case, if the judgment is for conviction and the accused's failure to appear is without justifiable cause, he or she shall lose the remedies available against the judgment. This was further discussed in the case of Hilo versus Sandigan Bayan, penned by Honorable Chief Justice Maria Lourdes Sereno, where the Supreme Court explained the consequences in the event the accused failed to appear without justifiable cause at the promulgation of a judgment of conviction to quote,
except when the conviction is for a light offense, in which case the judgment may be pronounced in the presence of the counsel for the accused or the latter's representative. The accused is required to be present at the scheduled date of promulgation of judgment. Notice of the schedule of promulgation shall be made to the accused personally or through the bondsman or warden and counsel. The promulgation of judgment shall proceed even in the absence of the accused, despite notice. The promulgation in absentia shall be made by recording the judgment in the criminal docket and serving a copy thereof to the accused at their last known address or through counsel. The court shall also order the arrest of the accused if the judgment is for conviction and the failure to appear was without justifiable cause. If the judgment is for conviction and the failure to appear was without justifiable cause, the accused shall lose the remedies available in the rules of court against the judgment. Thus, it is incumbent upon the accused to appear on the scheduled date of promulgation, because it determines the availability of their possible remedies against a judgment of conviction. When the accused fail to present themselves at the promulgation of the judgment of conviction, they lose the remedies of filing a motion for a new trial or reconsideration in Rule 121, and an appeal from the judgment of conviction in Rule 122. The reason is simple. When the accused on bail fail to present themselves at the promulgation of judgment of conviction, they are considered to have lost their standing in court. Without any standing in court, the accused cannot invoke its jurisdiction to seek relief.
applying the foregoing to your husband's case, there are several types of robbery under the revised penal code, all of which carry heavy penalties. Therefore, robbery is not a light offense, which is defined under Article 9 of the revised penal code as amended, consists of those infractions of law or the commission of which the penalty of arresto menor or a fine not exceeding 40,000 pesos or both is provided. As such, his physical presence is required during the promulgation of his judgment. His failure to attend the same may result in losing his right to appeal the judgment or avail of any other remedies unless within 15 days therefrom he surrenders and files a motion for leave of court to avail of the remedies, explaining the reason for his absence following Section 6, Rule 120 of the Rules of Court. We hope that we were able to answer your queries. Please remind that this advice is based solely on the facts you have narrated and our appreciation of the same. Our opinion may vary when other facts are changed or elaborated. Tomorrow, we'll look into another question from our viewers and readers of Dear PAO. This is your host, Dr. Presida V. Rueda Acosta, the Chief Public Attorney of the Republic of the Philippines. Goodbye for now.